Okay, welcome everybody. I am Peter Conlon, representative from Cornwall. 30 years ago, I was a young newspaper reporter at the Addison County Independent in Middlebury. And I was covering education as one of my beats and was really watching the school districts in my area struggle under Vermont's foundation formula back then, which had become sort of so counterproductive that it became actually an impediment to wanting to build housing, because the more kids you had in your school building, the more the local tax went up. And it was just simply, we were one of those areas where it simply didn't work for us. As a reporter, we started hearing rumblings about one of our local school supervisory unions kind of saying, this isn't right, and we might sue about this. And sure enough, that's what happened. They put the name of Amanda Brigham on a lawsuit. She was a young student from Whiting, Vermont, right next to Cornwall, where I live. And the lawsuit really went from there to sort of highlight, from a student's perspective, what the impact of the inequities we had in our funding formula were across Vermont. And really 30 years later, that name has become synonymous with Vermont's commitment to equitable education for all Vermont's children. Tonight, we're going to learn how we got from then to now and what lies ahead in the context of this Vermont Supreme Court decision. Before I turn things over to our moderator, Representative Herb Olson, just want to take a moment to thank him, thank Molly Moore from the Speaker's office for the tremendous effort that they put in to put this panel together. If you just join me in a round of applause for them, and I'm going to hand it right off. Thanks very
much. Thank you, Representative Conlon. My name is Herb Olson. I have the privilege to represent the wonderful towns of Bristol, Lincoln, Moncton, and Starksboro in Northeast Addison County. At the request of the member from Cornwall, a member from Brattleboro, I had the privilege of trying to organize and indeed have organized a panel of very distinguished attorneys who have expertise and experience in connection with the Brigham lawsuit that Representative Conlon mentioned. There have also been some subsequent cases following Brigham that decided cases where the facts were different, the claims were a little different than Brigham, and so they'll be describing that progeny as well. The hope is that this information will prove useful as the legislature considers Vermont's education financing system this session. After the presentation, the floor will be open for legislators to ask questions for the panelists, and I'll start introducing the panelists. Our first panelist is Peter R. Teachout, who is a professor at law at Vermont Law School. Professor Teachout is recognized widely for his expertise regarding the constitutional law of Vermont and the United States. Professor Teachout received his bachelor's degree from Amherst in 1962, his law degree, Harvard Law School, 1965, master's degree from the University of Sussex in England in 1966. Professor Teachout joined the faculty at the University of Washington in Seattle in 1970, served on the faculty there until he left in 1975 to join the faculty at Vermont Law School. Professor Teachout's expertise has been frequently tapped by both the legislature here, the Vermont judiciary, on a wide range of constitutional issues, ranging from proposed flag desecration amendment, free press rights of student journalists, education financing, as well as various amendments to the Vermont Constitution. Our second panelist, James Valenti, is president of the law firm Costello, Valenti & Gentry in Brattleboro. Mr. Valenti was legal counsel to the plaintiffs in a recent Vermont Supreme Court case involving Brigham and school funding, Boyd v. State, 2022. And so Mr. Valente will discuss the issues raised in Valente, in Boyd, and its background. Mr. Valente's legal practice focuses on litigation, many years of the law, homicide, land use, lots of appellate work. Mr. Valente is a product of Vermont's four-year law office study program, educated in schools, public schools, Marlborough and Brattleboro, which led to his interest in school funding. Third panelist, Joshua Diamond, the Dinsey Law Firm in Burlington. Mr. Diamond graduated from the University of Vermont in 1990, received his law degree from George Washington University in 1992. At Dinsey, Mr. Diamond's practice includes civil litigation, regulatory matters, government relations, employment and labor law, and family law. Mr. Diamond was Deputy Attorney General for a number of years. And then after that, he was on a legal team that successfully challenged Vermont's education finance system in the Brigham case. So we'll start with Professor Teachout's presentation, followed by Mr. Valente, Mr. Diamond. And then at the end of those presentations, they'll ask a few questions of each other, but then we'll be opening up to legislators to ask questions of them. Without anything further, Professor Teachout.
Thank you. Does this work? Is this working? Yep. Okay. Thank you, Representative Olson. It's my privilege to be here. I'd like to begin by making a couple of preliminary observations. Our task here today is to discuss the constitutional parameters of education funding reform in Vermont. And I just want to stress that when you're talking about parameters, you're talking about the outer bounds of what is permissible with an education funding system and very general constitutional directives. So within that context, you are going to have a great deal of flexibility in deciding exactly what form you think education funding ought to take in this state in order to provide the students in this state with the best possible education. Just the outer bounds, general constitutional standard. Second point I would like to make is that there are really two major constitutional issues stemming from the Vermont Constitution, two types of issues. The first type of issue is the one we're going to be discussing tonight, that is the Brigham case and the parameters that that case establishes on education funding plans. What was that case about? What was the standard that the court announced in that case? And what are some of the questions that have arisen about how that standard should be applied? There's another set of issues which we are not going to discuss tonight, and that involves whether the education plan adopted by this body complies with Article 3 of Chapter 1 of the Vermont Constitution, which is the article, it's the religious freedom article, and it contains the compelled support clause. And there the question that this chamber will have to ask at some point, but not tonight, is whether any plan adopted by this body complies with, one, the Vermont constitutional standard, and also the federal constitutional standard under the First Amendment of the federal Constitution, which contains the free exercise clause. That's going to be a little more of a challenge, I think, but in any way, I just want to say that's a second important constitutional issue to be put off to some other session. So, Brigham 101. You've already heard about the context of the Brigham decision. Basically, there are three elements that I would like to stress. Under the foundation formula that existed at that time, the ability of a local community to raise revenues to support its schools was primarily through the local property tax. Two, tremendous diversity in taxable property value from district to district. And the consequence was tremendous diversity in per pupil spending from district to district. This was a big issue in this legislature before the Brigham case. Legislature found it difficult to take action because there's a lot of self-interest involved and resistance to making change legislatively. So the Supreme Court steps in the Brigham case and was asked to decide whether the approach adopted at that point in time to funding education was consistent with the Vermont Constitution. How are we doing back there? Okay. Okay. So the big issue then was the disparate and unfair treatment of property poor communities versus property rich communities, because property rich communities had much more capacity to support their local schools than property poor districts did. So what did the court hold in Brigham? I've got the court holding up there on the board. It's pretty simple, straightforward holding. The current educational financing system in Vermont violates the right to equal educational opportunities under Chapter 2, Section 68, which is called the Education Clause, and Section 7, it should be, Article 7 of Chapter 1, which is the Common Benefits Clause. Those two clauses read together, the court said, provide the constitutional standard, and the system that had been established for providing education funding at that time violated the right to equal educational opportunities under those two clauses. There's a key paragraph on page 397. I won't read it because I'm going to refer to some of the elements in that paragraph in my discussion that follows. So the first question is a pretty simple one. What is the constitutional standard that Brigham establishes? And this is how the court put it. We hold only that to fulfill its constitutional obligation, the state must ensure substantial equality of educational opportunity throughout Vermont. That's the test. It's a pretty simple test in abstract expression. It opens upon problems when you think about how it gets applied in the concrete. But anyway, that is the standard. That's the constitutional standard that the court establishes in Brigham. There were three, as I read it, key aspects of the Brigham decision. The first is that the court rejected adopting an adequacy standard. Some states have said, you know, the constitutional test is whether some minimum level of education is provided. Vermont Supreme Court in the Brigham case said, we're not going to decide the Vermont constitutional issue on adequacy grounds. There's another standard that we want to employ, which is equality of educational opportunity. And then the second major aspect of that ruling, the court said, state constitution does not require absolute equality of treatment from district to district. It requires substantial equality. You can imagine that substantial has a lot of different possible readings and understandings, as we'll see tonight. And then finally, the court, It also said that the measure is not per pupil equality and per pupil spending. The court says something like this, and I think it makes sense. Per pupil spending is kind of a rough measure of a community's ability to provide educational opportunity, but it's not the only measure. There are a lot of reasons why per pupil spending is not the constitutional standard. So there you've got it. The constitutional standard is, does the education funding plan adopted by this body provide substantially equal educational opportunity? So I want to just go through some pretty simple elemental questions that anybody has about how that standard gets applied. So may the state formula take into account disparities from district to district in the costs of providing education. Some communities face much more substantial expenses in providing education than others do. And the answer to that question is clearly yes. The Brigham case itself, the court said differences among school districts in terms of size, special education needs, transportation costs, and other factors will invariably create unavoidable differences in per pupil expenditures. I know that the state now employs something like a weighted pupil share approach, which takes some of those factors into account in determining a district's share. And it's very clear from the Brigham case that that is permissible under the Brigham ruling. Those kinds of differences in costs can be taken into account in providing that substantially equal educational opportunity. What about disparities in taxable property value? The answer to that is pretty simple. Yes, any plan has to take those disparities into account. In fact, the court says you cannot make educational opportunity be dependent upon differences in taxable property value from district to district. Here's a little bit more of a sophisticated question or complex question. What about differences in district resources? May the funding formula take into account the fact that some communities have more substantial resources for supporting education than others do? So it's not the costs of providing education, it's the resources that a community has. Why do I ask that question? I ask that question because if you look at median household income in the state, you are going to find radical differences from community to community in terms of median household income. The median household income in Norwich is probably at least twice the average median household income. You have more income in a community, you therefore can afford to raise taxes at a higher level than communities that don't have that same level of median income. Is that permissible under Brigham? And the answer is, I think yes, although the court was talking about differences in taxable property value there, but the court standard in Brigham is not district property wealth, but district wealth. I think our current formula does take that into account more or less indirectly in terms of the excess spending formula. So communities that regularly raise their taxes above the level of other communities can do so up to a point, but when it reaches like more than 121% at the average, then the taxes go steeply up for the community. I think that reflects the sense that communities with a lot of income can otherwise afford to tax themselves at a higher rate than communities that don't have a lot of income. So a couple of other quick questions. What about local involvement, local control? What does Brigham say about that? What the court said in Brigham is equal opportunity does not prohibit cities and towns from spending more on education if they choose. So the answer is the formula can take local control, local involvement in spending decisions into account, and our current formula, in fact, does allow that. Does the formula have to do so? I don't think so under Brigham. Finally, just two other questions. I'm out.
Professor Teachat has additional questions. They're on his PowerPoint. If folks have questions at the end, some of them are very relevant.
Okay, I apologize
No,
for
no.
gone over just a little bit. So we can get to those questions later.
Yeah, there we go. Appreciate it.
Okay, so I'm James Valenti Fortunately, I don't know as much as either other presenter, so this will be quicker. And actually, I was thinking about this just now. I believe Mr. Diamond has never lost a school funding case, and I've never won a school funding case. So you should probably take what I have to say with a grain of salt. So the area of my knowledge is very narrow. It's really just this one case, but that did require some background. And because I was actually involved with the case, I would be able to tell you folks a little more about the facts that don't necessarily make it into the Supreme Court order. So I'm not going to do much background on Brigham. I don't think you need it. Brigham 2 is interesting. If for nothing else, then you have two Brighams and you have Whiting and Whitingham. Anyway, if you don't know, Whitingham is on the Massachusetts border in Windham County, the big reservoir with the glory hole and all the power stuff is in Whitingham, and that's a huge property taxpayer. So they were like a town with a ski area, but their ski area was a reservoir. And they, after Act 60, brought Brigham 2 as a group of students, which I didn't put in here, but Mr. Diamond helpfully pointed out, and a group of taxpayers arguing that the buildings are falling apart and the offerings are too few and our taxes are too high. And essentially that Act 60 and Act 68 had swung the pendulum too far, so that the formula that was meant to equalize had in fact taken a former gold town and made it, I don't know, a pewter town. The timing of the Supreme Court decision there was important. It was at dismissal. And so the Supreme Court was really just saying, okay, theoretically, if all of the facts are exactly as you say, should you be able to get a decision from the court? In other words, it was a very low standard. And the Supreme Court reversed the lower court, which had dismissed, and said, this should be factually developed. It's theoretically possible that this claim could have legs. Now, after that, litigation takes a long time. Whitingham is a small town. Appeals cost a lot of money. They actually decided not to go forward at the trial court level, even though they won their appeal. But about a decade and a half later, I think they said, now is the time. There were some changes because their school districts merged with another school district, but basically the claim in Boyd was a continuation of the theory advanced by Brigham 2, except we finally got somebody with a name other than Brigham. I tried to make this into a simple metaphor that is frankly not very elegant, but the idea is that every district is forced to buy a student a car. Whitingham's paying for a Lexus. Into the state, they get a bicycle back. And for those of you who don't know, Whitingham is a K through 12 school. My mom taught there for a year. It's in Windham County considered like the most rural place that can sustain a high school because it's so isolated. They can't bus their kids to Brattleboro Union, or I think the next one is actually in Greenfield, Mass. And so they're forced to have a high school because of where they are, but it's anywhere between like 150 and 250 kids, K through 12. So you're talking about a big building, a wide area. It's a very large town, but they have to do things like group multiple grades into classrooms. If you went to a small school like I did, this is normal, but my wife tells me that it is most certainly not in other places. So anyway, Boyd versus State of Vermont went past dismissal and into the next phase, which we call summary judgment, which basically meant we, on behalf of the town of Whitingham, got to hire an expert, an economist, to try to make the connection between the funding scheme and the consequences that Whitingham said flowed from the funding scheme. And the reason that the claim was unsuccessful is because ultimately we failed to do that. And if you want to sort of understand that question better, I think it's helpful to imagine, well, how do you distinguish a well-funded school with a terrible administration that has very bad facilities and teachers who are not doing a good job and a building that's falling apart from a school that has bad facilities and bad teachers, et cetera, because of the funding scheme. In other words, how do you show that causal connection? And we didn't do that. And to just candidly, that was the most difficult part of the case, was figuring out how to fill in that factual record. One of the things we did was sort of solicit opinions from the townspeople and our office. And that's why we made a number of suggestions for standards the court could use to assess opportunity. What classes do you offer? What extracurricular activities are there? AP classes, vocational stuff. They just didn't have a vocational program, period. And if you knew the sort of character of this town, that's insane. A ton of the parents are tradespeople. Standardized tests, kneecap tests, dropout rate. We tried to imagine, like, if you were moving to this town as a parent, what would you look at if you were assessing the school? But again, Whitingham statistics for all of those things at the time, and I think now, were what you would generally consider bad. I know that's like a loaded term to use for school and standardized testing. But how do you prove that it is the consequence of the funding system rather than the administration or to the student culture or whatever the issue is? And so we were able to show that Whitingham's per pupil costs were very high and the objective measures were not great, but the connection was something that wasn't factually proven. We also challenged the funding system generally. And the idea was that there was sort of a donut hole between the incentives meant to help really small schools and the very small schools that don't quite qualify for those incentives, but also lack any economy of scale. And I can tell you that is a suitable description for Whitingham. And in challenging this, we tried to recreate the analysis from Brigham to say that essentially, if you look at the outer extremes of per pupil funding, the richest and the poorest, post X60, X68, and everything that's come since, it's actually not that different. And at the polls, that is true. It becomes more complicated the closer you get to the middle. It's actually more mathematically complicated too. Just for the heck of it, I made a 2025 table of the top 5 and bottom 5. So this is this year's school budget that people are arguing about in the towns right now. And just to remind you, the extreme example provided in Brigham was a 259% top to bottom differential. And you can see that under the current system, at least at the outer polls, you still have a pretty substantial differential between the so-called gold and pewter schools. So that's where things stand with respect to Boyd. Please don't ask me questions about the current equalized formula because I learned it 5 years ago. And really my narrow expertise is here, so I'm going to hand it off to a more qualified speaker.
Hardly, but thank you, Attorney Valente. Joshua Diamond, it's a pleasure to be here with you. Representative Olson, thank you for convening. And members of the Vermont Legislature, thank you for hearing us out today. I'd like to take the liberty for a moment just to talk a little bit about the context of Brigham and when it was brought. But before I do, I want to recognize someone who unfortunately is not here today, a friend, a colleague, a mentor, and his name's Bob Ginsberg, because we would not be talking about substantial equality of educational opportunities without him. There was a team of lawyers that brought the Brigham case. I was one of the members, but the lead was Bob Ginsberg. And it was Bob's legal acumen, his leadership, his insight, his incredibly big heart. He put his private practice on hold to bring this case at a lot of personal sacrifice. And I just want to remember Bob for what he did for the state of Vermont at the end of the day. So the context, as you may have heard from Professor Teachout for a few moments ago, was that we were challenging the foundation formula. And that was a formula that was brought about I believe in the mid 80s, with a good deed in mind, but it was designed to provide minimum quality education, not equal access to education. And as a result, there were just significant disparities as we were looking at our educational system in the 1990s. And in fact, under the foundation formula of that day, 60% of funding for our local schools was dependent upon our local property tax base. And there was no equalized grand list back then. So you could have towns like Stannard that had about $118,000 in their property tax base per pupil versus a town like Peru, which I think is down in where Stratton ski area is. They had 2.5 million. So you can only imagine the disparities and how easy it was for a town like Peru or Stowe to raise their taxes and create great spending, great schools, while other communities really struggled. Some of the examples of those inequities back then were Wolcott, which was in the lower 5% of educational spending, had about just over $1,800 per pupil spending, while Stowe at the 95% end had closer to 13,000. Eden was just under 3,000, and Windhall was at 7,700. But it was an anecdote, if I may share with you, when I was helping prepare the case that really drove it home for me. I was interviewing school officials in Hardwick in preparation for the Brigham case. And we were talking about what is the impact on your local school. They had a tax rate that was probably above $2 per 100. It was very high. Stowe was much less, maybe 10 cents, 12 cents. Don't hold me to those numbers, but very, very low. And they had a very high property tax burden. And what one administrator said to me of an elementary school is, we can't guarantee that each child will have the basic Title I supports. This is the basic remediation math and reading supports that young kids really need to get up to grade level, because if they don't get there, the statistics will tell you, educators will tell you, they've got a headwind in front of them for success in life. And the fact that this administrator who cared so deeply for the children of that school district couldn't provide that basic service. We're not talking about football. We're not talking about violin lessons. We're talking about basic reading and writing and math. And that really struck with me. So we brought the case. We did not bring the case as an adequacy case. This was about equality. And the Supreme Court luckily agreed with us at the end of the day. For those law geeks like myself out there, I just want to take a brief moment to talk about how we got there, and then I'll talk about Vitale. We made an argument that education was a fundamental right based upon the text of our Constitution, about the history and tradition of recognition of the role of education, and that it was implicit in the concept of ordered liberty. And the Supreme Court latched on to part of that argument, and in particular about Chapter 2, Section 68, which is our constitutional provision that deals with public education. And it says, the laws for the encouragement of virtue and prevention of vice and immorality ought to be constantly kept in force and duly executed, and a competent number of schools ought to be maintained in each town. And when the Supreme Court really dug into that history, they focused on virtue and the historical fact that schools played an integral role in making sure that we had educated citizens to function in a democracy, and really link those two together. And therefore, this was an important constitutional right that needed to be recognized, and the system that we had was equitable under the Common Benefits Clause, which is our equivalent to the Equal Protection Clause. And Professor Tichat, you did a great job of summarizing what that holding was at the end of the day. And I'm going to shift over to slide 10, if that's okay. But there were some, from my perspective, some open questions coming out of Brigham. And I just want to identify them, at least ones that I had in my mind, and then talk about a case that came up about 2 years ago that I think in some ways answered some of these. But the four questions that I think Brigham still didn't necessarily decide explicitly was, is the right to education a fundamental individual right? Are the rights in Brigham limited to educational funding? what is the constitutional framework to evaluate these types of cases? And with a new Supreme Court, are they going to really relook at Brigham, or do we have some concepts here that we can rely upon? So I think an illustration or an answer to those questions came about in a case called Vitale about 2 years ago. And this was a challenge brought by, I believe, parents of school children who wanted a right to access the tuitioning component of our statutes that allow for payment of private schools, even though their community had a public school. And so they were saying, hey, why can't we send our kids to a private school like a rural town in maybe the Northeast Kingdom? And they argued as well, we've got kids who've been bullied, they've been harassed, they've been discriminated against, we should have that kind of access. And the Supreme Court said no. So this case isn't really directly on point to some of the educational finance issues, but when the Justice Eaton got into deciding this case, he really answered many of those questions that we posed before. And I'd like to just chat with you about that for a moment. So the first question, is the right to education a fundamental individual right? And why is that important? That's important because many courts, when they have a fundamental right at stake, are going to give much more scrutiny to that underlying question, as opposed to maybe say, you know what, we're going to defer to the legislature, we're going to defer to the government. They're going to scrutinize the question more when a fundamental right is at stake. And Justice Eaton for the court held that yes, the right to education, because it's integral to our constitutional form of government, this is a fundamental right to education under the Education Clause of the Vermont Constitution. The second question, are the Brigham rights limited to educational funding? And the answer, as Justice Eaton wrote about, is no. He wrote, Brigham I did not hold that money is educational opportunity. In Brigham, there was undisputed evidence of the link between funding and educational opportunity. Some differences in funding are permissible due to each school district's different needs and costs, but a system in which educational opportunity is necessarily a function of district wealth is prohibited. So those, as similar to Professor Teachout talked about, those are kind of the guide rules that we have even today, and that the state is ultimately responsible for any inequities that exist. Well, what is the constitutional framework for evaluating these cases? We brought this case initially under the Vermont Constitution because the federal Constitution said that education was not a fundamental right in a case in the early 70s called Rodriguez versus San Antonio School District. And Vermont in the late 90s and early aughts was really developing its own constitutional analysis. Baker versus State really kind of cemented how we look at equal protection claims and developed a standard that is unique, at least compared to the federal model. And so Justice Eaton also wrote about, well, how do we evaluate these claims? And there's two types. One is if where the government benefit has been identified or challenged is education in of itself. And if that's the case, we're going to use the test, which is there substantial equity of educational opportunities? And the court held in Vitale that the issue of the ability to have access to tuitioning was not a fundamental educational opportunity at the end of the day. It was unlike a question about curriculum, a question about access to technology and access to human resources. But the court moved on and said, well, we're still going to analyze the equal protection claim based upon that which was developed in Baker versus State. And there's essentially three parts to that test. One is we're going to define the part of the community that's been disadvantaged. The second is identify the governmental purpose that is excluding a part of the community from that benefit. And then three, ascertain whether that omission from the benefit or protection and security of the challenge law bears a reasonable and just relationship to the governmental purpose. And there are a few other, I don't want to call them micro criteria, but other factors to consider for that third part. So the fourth question, with the new Supreme Court, right, we've got all new justices now than what we had in 1997. Could the underlying principles of Brigham change in new litigation? My opinion is no. I believe the Supreme Court has reiterated in recent cases, whether it be Boyd or Vitale, the underlying principles that were articulated in Brigham. I do think there are still some questions to be answered. We have not fully litigated, I think, the claim of an individual student, not bringing a facial challenge to the system, but to their individual circumstance that they don't have access to equal educational opportunities. I think that was the question that in Brigham 2 was never fully answered. The court seemed to indicate that that claim could go forward, but we never knew what the results were because the litigants, as we heard, had moved on at that time. So more to see how things shape up. I know you all have a lot of work ahead of you, and I just want to say thank you for the opportunity to talk about Brigham.
Thanks very much to all the panelists. What we're going to do right now is give the panelists the opportunity to offer, maybe a question for each of the other panelists. After which, you folks get to have your say and your questions hopefully answered as well. Professor Teachout, do you want to start with a question for the panelists?
Look, I think the large question is what that mandate. The state has a constitutional mandate to provide substantially equal educational opportunity to all the students in the state. We know as a matter of reality that there are substantial differences today in the quality of education that is provided from district to district. One example is the example that Attorney Valenti gave. Why hasn't the court got involved in saying, I'm sorry, but the state has failed to meet its constitutional obligation in this context? And I think the answer is the court does not want to get involved in micromanaging the system and is prepared to tolerate considerable differences in the educational opportunity offered from one district to another district, even with respect to individual students, because it knows once it opens that up, it's going to be in a constant process of saying, well, wait a minute, this student in this town is being denied that, but across the state, not so. So at least that to me is the crucial issue. And I wonder what your thoughts are about that.
One thing we were not able to do, but which might have established a lack of opportunity, if we could have identified within all of the data a subset of school sizes or schools with common characteristics that all had roughly the same degree of poor test scores, poor performance, high dropout rates. If you were to really look into the top 5, bottom 5 table I made there, one of each of those 5 is a large district, one is a very small, and there's a couple of in between districts. And so I think that if I wanted to make the facts suit the argument, I would get a spreadsheet out and say, look, schools between 300 and 500 in towns that have some commonality, low in household income maybe, or low property values, we can show that when you put this on a chart, there's a very, very clear problem for the students here. And it's not just Whitingham School, it's schools of this type.
Just a quick follow-up. So the problem for the court would be that, is the court then going to invalidate the formula that the state employs for determining per pupil spending from district to district? That's the problem. If they invalidate the formula, then that's going to throw a wrench in the monkey work. So
I pass this one to Mr. Dime.
Well, I don't want to always speculate about what the court may do, but I do feel that the court is very cognizant of the separation of powers and has a lot of respect for this body, and has said in its opinions that it wants to give the legislature the opportunity to come up with the means subject to the constitutional principles. So I think there is deference in that, notwithstanding the fundamental rights component. But the fact that Justice Eaton really came out and said, or the court came out and said, there's a fundamental right involved, at some point they're going to have to address that question, and the right, facts could make a change. But I think it's a tension between the two branches of government against an individual fundamental right that is in play.
I'm taking the mic here. It's time for legislators. We have three folks who know quite a bit about this subject matter. So open it up for questions. It just asks that maybe say your name, just so people know who you are. I don't even know who everybody is. Okay.
Cool. So first of all, as the longtime CEO of Danforth Pewter, counselor, I object to your describing lower performing schools as pewter schools. However, I would be willing to settle out of court with you. My question is this. I believe that you said collectively that the court held that school districts raising additional money on their own was allowable. And I wonder if there's any standard by which to judge when that, like how far that can go before it leads to inequality of educational opportunity.
Who wants to take a stab at that? Sure. Make sure that I restate it correctly. I think you're asking whether there are any limits on the ability of a funding system to allow individual districts to raise some additional funding for their schools. Is that it?
So the current formula employed by the state does allow individual districts to raise taxes above the statewide average, to raise per pupil spending above the statewide average. But if they want to do that, and the increase is, I think, above 21% of the state average, then the taxes go up dramatically at that point. So that's called the excess spending clause. And that seems to be, it's permitted under the Brigham standard, whether it's good policy. It is permitted under the Brigham standard because of the courts holding that whatever you do, the level of educational opportunity ought not to be simply a function of district wealth. And that excess spending clause reflects that consideration.
Any other questions?
This is a very basic question, but I've been confused. When we give a family a voucher, are we not essentially foundation funding at an individual level? So the family uses the voucher to send somebody to a school in Japan or a private, very expensive private school, and then pays the rest out of their own pocket. Is that not like foundation funding? Is that not against Brigham?
Couldn't quite hear the very end. I think I get the gist, but
yeah, just so if Brigham is against the foundation funding, if I understood that. Okay. But we can give a family, we can give a household a voucher that can be used to then go get a very different education at a fancy private school abroad, maybe. Is that not essentially allowing someone in a different school district to pay way more than 125% and achieve a very different educational outcome?
Let me restate it because I think I gave, the question is what sort of limits there are, I think, on the ability of a district to offer above a certain amount, whether there are any limitations imposed by Brigham in his cases on that incremental above a certain amount. Yeah.
So please tell me if I'm wrong, or if you just want to go for it again.
No, I want you to be my anger translator.
Okay. So for districts that might have tuitioning, whether at whatever grade level that is, if a certain amount is provided by the district or the state towards that student's education, and then the family itself can provide significantly more dollars on top of it, and in doing so, create an entirely different educational opportunity than a student in that district that only has that, say, average educational spending amount available to them. Does that not create significantly different educational opportunity, and perhaps with the right facts of the case would not be?
I'd have to give this a little more thought, but the inequity, I think, is being driven not by the governmental funding, but by the family member, presumably the family member that is paying the additional incremental amount. So I don't see that as being problematic from a constitutional perspective, maybe from a policy, but not from a constitutional one.
I agree for what it's worth.
And I agree for what it's worth too.
The original Brigham decision was made in an environment where the state had a foundation formula funding mechanism. Does that mean that the Brigham decision is adverse or prevents any form of foundation formula going forward? Or is it just the specific one that was in place at the time didn't meet the constitutional requirements, and that maybe something formulated differently would be acceptable?
If I understand the question, and I may not understand the question, it is, does Brigham prevent any use of something like a foundation formula?
Right.
Yeah. No. What Brigham does prevent, bottom line, is that educational opportunities in this state cannot be made a function of district wealth. Now, when it was talking about that, it was talking about district property wealth. But the term and the standard that the court employs, education may not be made simply a function of district wealth. So you can use something like the foundation formula, but that is the line over which you cannot pass.
Anything else?
The devil's always in the details, right? So that foundation formula back in the 80s was not designed to get at equality. It was designed to get at adequacy. And the other problem I think that happened that exacerbated the inequality was that the legislature didn't fully fund the obligations year in, year out from where it started. So in some ways, it may have been designed to fail.
I just wanted to add, I think you could argue that there is sort of a shadow foundation out there under the current system that at some point the Supreme Court would say the funding system doesn't satisfy. And it would probably have to do with the delta between the polls that I pointed out, but also the fundamental question of, does the system allocate enough for opportunity, period? And I think it's like the difference between the plural noun foundation formula and what is really happening with the funding. But I also agree, you could have something that looked sort of like a foundation formula as long as it functioned in a way that didn't create these massive gaps by virtue of geographic coincidence.
Thank you.
Hello. Just to follow up on this question about the voucher. So if you're in a situation where say, I don't know, a student is not being served by their public school, and so their family gets pushed into a position of needing to use a voucher, but they don't actually have the funds to, I don't know, meet the additional tuition costs, would that then create this issue of creating kind of this like micro block, unequal block at the individual family level?
Can you check?
Emily Karras Duncan, representative from Whitingham.
So I'm trying to imagine a circumstance where, yes, there may be a circumstance where a kiddo who's got access to a voucher can't get into an Exeter or an elite school. But there are public schools throughout this state that I'm sure would be happy to take those tuition dollars and access to education and presumably equal educational opportunities by virtue of access to those schools would exist.
I'm not necessarily talking about like an elite education, like an Exeter or something, but I'm just imagining like, say we have a family that has a gifted student whose needs are not being met by the local school, but the voucher dollars are not covering the cost of where they would need to go to get their needs met.
I'm not sure that equality requires meeting those particular needs, but I'd be curious to hear from.
Well, what I was thinking about, and Josh may disagree because I was building off of, I think, something he alluded to as an unanswered question, is how do you apply this to individual students rather than school districts who are arguing about systemic equality of opportunity? And there is an absence of case law where a student by themselves, without taxpayers, without school districts, just says, hey, I want to do X and I can't, and this other student can do X, and that's not fair. I'm not sure Brigham would be of much use, but the constitutional issues that were clarified by Brigham and especially by Vitale recently would probably form the basis of the Supreme Court announcing how they would address that individual student's claim in the context of what amounts to sort of like sailing into a new water body without really being sure what's on the other side.
I hate to ask, can I use your district again? So let's say you have a district where about $1.5 million go across the border every year, passing that public school in some district in the southern tier. And many of those dollars are going to schools that maybe practice selective enrollment. Some of them don't serve kids with disabilities. So those students end up at that district in a concentrated situation of disadvantage. And other students who maybe have access to cars, don't have disabilities, can meet whatever more stringent standards are there for enrollment, can pursue those out-of-state opportunities. Does the effective defunding of that public school that is there to provide that common benefit to members of that community, which now doesn't have the scale or resources to provide it, how does that stand up as a constitutional issue, particularly when it's serving, as we know is true in Vermont, public schools serve a disproportionate number of tuition students who are economically disadvantaged or have disabilities? Is there an equity issue there?
So I think, well, I don't know, but I do believe it would open up another issue for, I'm just going to call them the parents that take their kids out of public school to put them in a preferential school, whether it's private or another district or whatever. It's sort of like how the right to free speech also encompasses the right not to speak. I think those parents would say, hey, one of the freedoms of educational opportunity is to pay your property taxes, but decide not to send your child to school in this district for whatever reason. It may be religious. I mean, maybe it has nothing to do with school quality. And I wonder, and I don't believe there's any law on this in Vermont. There may be in other jurisdictions. I wonder how the Supreme Court would approach a claim by somebody who said that essentially they should have the right of choice, period. I don't know much about Vital, but I wonder if Vital gave some guidance on this. Did it?
I think Vital stands for the proposition that school choice does not implicate the education clause. And so then you'd have to look at it from a different perspective, which is from the student's perspective that remain at the public school, and do they have equal access to educational opportunities? And I'd be speculating.
Yeah, the court in Vitale said basically you're complaining that you're not getting equal educational opportunity because you don't have the same opportunity that students in districts without a public school of their own have to send their kid to a private school that's funded by the state. And the court said basically you have not shown that there's a relationship between attending a private school and a difference in educational opportunity. So you failed to make out a claim under Brigham. Okay, that's a pretty simple question. The state does have an obligation to provide all the students in the state with equal educational opportunity. And if you're in a district with no public school, then it's pretty easy to claim that the state has some obligation to provide you with a school in that district that provides roughly equal educational opportunity with the kind of education that students get in districts with a public school of their own. So Brigham says you got to do that. I think there are some problems, and one of them is simply, what if the student's going to that private school because the private school doesn't have to meet all the requirements that public schools do? In fact, they're getting a much superior education to the kids in the public school. That is a kind of reverse Brigham case, but the court hasn't had to address it yet. I simply want to underscore the fact that in Brigham, the court said, look, here's the mandate. You've got to provide every student in the state with substantially equal educational opportunity. But how you meet that mandate, we are going to leave to a matter of legislative discretion. And so, as we've said, the court is unlikely to get into the process of micromanaging those individual instances where you and I would say equal educational opportunity is not being provided. The court is simply, if the formula generally is aimed at providing that kind of opportunity for all the students in the state, that is a matter we're going to leave to legislative discretion.
I want to raise a question. I'm still struggling with the issue of Brigham's focus on equality rather than adequacy. Because the more you talked about the practicalities of where the court wants to go or doesn't want to go, it seems to me that it kind of hinges on adequacy. In other words, if we were to adopt a foundation formula which said every school gets X amount of money, if there was any credible evidence that that X was enough to have an adequate education, the fact that some districts added on to that, I hear you saying, would not trigger probably intervention by a court. Brigham was motivated. But on the other hand, if that sum was clearly inadequate, and there was evidence that proved that that sum was inadequate, in other words, in a situation like when Brigham was, when the court addressed Brigham, where the legislature had failed consistently to fund it. So if that amount were clearly inadequate, and the difference in education was the difference between the inadequacy that all students faced in districts that could not tax more versus the students who were in districts who could tax more and thus had adequate education, that Brigham, the court might intervene on adequacy grounds. Am I not getting it right?
The plaintiffs did not bring an adequacy claim. Brigham does not speak to adequacy. Could an adequacy claim be raised in a new case under new theories? Possibly, but that's not what Brigham stands for.
It seems to me Representative Mahaley is taking issue with the Brigham court's approach to providing educational opportunities in the state of Vermont. He thinks maybe the court would have been wiser if it had adopted some sort of minimum adequate education. Every community that provides that, that's the end of the constitutional inquiry. I will tell you, the New Hampshire court, Representative Mahaley, adopted exactly that approach. They are still in court today, going over and over and over again what the legislature has considered to be an adequate education. And you know what the legislature in New Hampshire decides is an adequate education? It's one we can afford. That's the measure of adequacy. Okay, it's not a nice judicially manageable standard. Equality is, but there are also problems with the equality standard.
I agree that adequacy is inferior to equality. I'm just saying, it's hard for me to believe that you can make an equality argument in circumstances where you're faced with enormous inadequacy.
Go ahead. Going back to the issue of the ability to raise additional dollars on top of a foundation formula, to put it in real sense, that's probably a proposal we're going to see very soon. You talk about how it can't be dependent on a school district's property wealth in the Vermont context. And that's really easy to understand when we talk about Whiting and Stowe. But supposing we have districts that are 3 counties large and are roughly equivalent in property wealth and the ability to raise additional funds, does that then make the ability to raise dollars on top of an adequate base formula Brigham compliant?
You know, that's a really good question. And you wonder, why did the Vermont Supreme Court go out of its way to say that nothing in this formula will prevent a district from raising more tax revenue, if it wants to, provided the difference is not based on district wealth? And you wonder, why did the Supreme Court feel it was important to give communities that ability to decide, we value education more, we would like therefore to raise our taxes above the taxes in other communities in order to support that kind of educational opportunity? Brigham says communities can do it. The problem we have, if the pattern develops, that it just turns out that communities that have substantially higher median household income constantly are the ones that raise their taxes above the average. and the poor districts the income poor districts are not able to do so.
If I imagine that hypothetical in the context of Boyd, I think my immediate answer would be because we used so many schools in Chittenden County like CVU as exemplars of well-run schools that also could really take advantage of economies of scale. I would imagine that you would have a school district with Chittenden and then a bunch of big school districts without Chittenden County's just base. And how that differential was navigated would be very significant, because I would think the other districts would complain if it was just based on the core measures of the district, if there wasn't some equalization. But it's hard to speculate.
And while I would agree that if the ability to raise money is equal, what we haven't seen yet is a real full litigation of the individual student's fundamental right. If there's a student out in Concord versus Williston, and they've got real substantial differences in the educational opportunities that exist, that claim has not fully been litigated yet. So that's an unknown question, I think, right now.
Hi, thanks, Robin Shy from Middlebury. I missed the beginning, so if you answered this, then I apologize. But we talk about substantially equal education opportunity, and I'm wondering how opportunity is defined, because it seems to me that that could be a place where we have options for doing things. And when I think about, for example, in 1997, we didn't have a lot of the technology tools that we have now. So if people have access to technology, like everybody could take Chinese and it doesn't matter where you are. And is that an opportunity? So what do we mean when we say opportunity?
So I don't know the answer, but this did come up in Boyd, because if you were a student at Whitingham at that time and you wanted to take Chinese, you could do it at another school 40 minutes away. And some people could, some people couldn't. It's really difficult if both your parents work to make that happen. And Boyd started in 2017. So we didn't know it at the time, but there was going to be this revolution in remote education. And I wouldn't be surprised if one of the key questions of a future Brigham analysis is, if a kid who grows up in Marlborough, Vermont, can take a science class and watch it on a screen, is that an equal opportunity compared to a kid in Brattleboro who can go into a lab with soapstone counters and the torches and beakers and all of those expensive things? It's a tough question to answer. These guys might have something better than me, but I think you're getting really deeply conceptual in a place where the Supreme Court would be loath to go and say, well, you guys got elected, you figure that out.
So that underscores a recurring theme tonight, that the legislature has enormous discretion in coming up with an approach, a formula that, to the maximum extent possible, provides substantially equal educational opportunity. Every kid in the state. You can take into account all the things we've talked about. You've got the discretion. The court is probably not going to get involved in striking down that formula if the legislature takes its responsibility seriously in that respect. And Brigham is very clear about that. Here's the standard. How it is implemented, we leave to the discretion of the legislative body.
I agree.
First of all, Professor Teachout, with all due respect, when we've looked at the data regarding the correlation between districts' desire to spend and raise taxes and approve higher school budgets, there is no statistical correlation with a district's median income or the income of the students in the school. It's very counterintuitive, but in all the different ways we've run the data, that holds true. But my question is about, to moving away from specific examples, it seems to me, and I'm very, very far from an attorney, though I do recommend to everyone that you read the Brigham decision. It's pretty easy reading. That it seems a question of means and ends, and that Brigham is about ends, and the means are entirely up to us and up to school districts. And so my question is, regardless of what we do in this room and what laws we pass, it seems to me that what matters is the ends results and how that comes out in the wash of educational opportunity, and that it's not even the hypothetical educational opportunity. It seems like it's the results of that educational opportunity and the facts in the far off case. And so I guess I'm wondering, like, if we pass a law that isn't Brigham compliant, as people say it, that does not afford substantial educational opportunity, will that become clear next year? Or do the new facts need to develop before that is clear?
Yes.
I mean, I would just question the ability of anybody to pass a law that's compliant with an existing case to prospectively apply that case to the new law. That's a tough nut to crack, but
I think that's generally true, but I could conceive of a means that on its face does not allow for equal access to educational opportunities. So if the question is there any scenario where we don't have to worry about this as we design the means? I wouldn't answer that in the affirmative. But it may be that the devil's in the details and we have to see how things roll out.
you could curse.
What was that?
I'm good. I got the last question. Now I'm going to wrap us up. Would you like to share some concluding words before I share further concluding words? Representative Wilson?
Not really, other than I want to thank the panelists.
You have a mic.
What's that?
You have a mic.
Yeah. I want to thank the panelists for being here. I thought they gave good outline of the constitutional principles. I thought they handled the questions from legislators very well. And I thank the legislators for asking these questions, because this is what we're doing right now. And these are the principles that we'll need to work with. But I think one of the themes is that we have a lot of discretion within the confines of those principles to make this work.
On behalf of the speaker and Representative Conlin and myself, want to very much thank you personally for all of your work to put this together. I want to thank the three of you for traveling to come and debate hypotheticals with us. That is very appreciated. And appreciate all of you. We are often in the thicket of details, and I appreciate that folks wanted to spend their evening to get into the much bigger picture values and guidance that shape our work. I moved to Vermont in 1996. And my experience of Vermont, my sort of formative experiences of Vermont, was the aftermath of Act 60 and Take Back Vermont and all that fell from that. And so I feel my experience in the legislature is very shaped by that. And so I appreciate all of the history that you all have brought today. We were planning to make this a series of ongoing panels throughout the session. And we're planning the next one to be about the Carson decision. And fortunate to all of us, and especially fortunate to Molly Moore, there is already a panel on the Carson decision planned at the Kellogg Hubbard Library. And so I would encourage folks on February 12th at 7 o'clock to head over to the library to a panel that the League of Women Voters is sponsoring on the Carson decision, as sort of a next step in our legal continuing education related to education finance. Thank you.
everyone, and thank you all so much for being here.